Welcome to the channel, your primary source for deep dives into firearm law and the tactical market. Today, we aren't talking about new builds or accessories. We are standing on the threshold of history, an event that generations of American gun owners have only dared to discuss in theory. On March 27th, the most powerful alliance we've ever seen, consisting of the National Rifle Association and the Firearms Policy Coalition, officially opened fire on the heart of the National Firearms Act of 1934, better known as the NFA. This isn't just a minor dispute in a single state. It is a direct assault on the legal foundation that has shackled your rights for nearly a century. To understand why this lawsuit is being hailed as a legal earthquake, we have to look back at the yoke of the NFA. Since 1934, the federal government has used its taxing power to control, restrict, and effectively prevent the vast majority of citizens from accessing machine guns, short-barreled rifles, or suppressors. Back then, a $200 tax was a staggering sum, equivalent to thousands of dollars today, turning a constitutional right into a luxury for the wealthy. But even more restrictive than the money is the mandatory registration and the grueling wait times the ATF imposes on every buyer. This new lawsuit declares that mandatory registration and taxation for items protected by the Second Amendment is a blatant violation, and no longer fits the history and tradition of this nation. Imagine, if this lawsuit prevails, the entire structure of ATF control over restricted items will collapse like a house of cards. Concepts like SBRs, SBSS, or even fully automatic machine guns manufactured after 1986 could be brought back to the civilian market without bureaucratic red tape or arbitrary taxes. This is an all-in play by gun rights organizations. They are no longer looking for compromise. They are looking to dismantle these irrational barriers entirely. The channel will be providing constant updates from the courtroom, because the outcome of this case determines whether you can own your preferred hardware without asking anyone's permission in the near future. The reason this lawsuit has a firmer footing than ever before is the Supreme Court's Bruin decision. That precedent fundamentally changed how courts must evaluate gun laws. Instead of using vague government interest tests, all laws must now be judged against the history and tradition of the Second Amendment as it was understood in 1791. This is the ATF's Achilles heel. At the time of the founding, the fathers did not impose a $200 tax stamp or keep a registry of weapons. By using the Supreme Court's own sword, the NRA and FPC are hacking away at the chains of the NFA. For FFL dealers, this is a signal of both excitement and caution. Excitement for a massive market expansion, and caution because current management procedures could be flipped upside down overnight. This legal narrative isn't just about ownership. It's about the dignity of gun owners. For decades, you've been treated like a potential criminal for wanting a rifle with a barrel a few inches shorter than the arbitrary limit. The March 27th lawsuit challenges that very logic. It asserts that owning a firearm, regardless of type, is a natural right that cannot be infringed through disguised taxation. We are talking about millions of users, thousands of businesses, and a massive economic ecosystem that will shift if the NFA is declared unconstitutional. The next legal steps will be grueling, but with the combined might of the NRA and FPC, the community has a position of strength we've never seen before. To dive deeper into why this alliance chose this specific moment to attack the financial core of the NFA, we must discuss the true nature of the so-called tax stamp. Remember, in 1934, that $200 tax wasn't a random number. It was a calculated economic barrier. At the time, that tax was equivalent to the price of a state-of-the-art Thompson submachine gun. This lawsuit argues that a tax cannot be used as a tool to extinguish a constitutional right. If the government cannot charge you $200 every time you go to the voting booth, why should they be allowed to tax your right to bear arms? This absurdity carries a heavy procedural burden for both FFLs and buyers. Every time you pay for a tax stamp, you aren't just losing $200. You are entering a void of endless waiting, 6 months to over a year for the ATF to process a Form 4 or Form 1. For gun shops, this is a massive administrative nightmare. If the tax and registration are ruled unconstitutional, you could walk into a store, pass a NICS background check, and take your suppressor or SBR home the same day, just like a standard firearm. The lawsuit also aims to clear up the blurriness of NFA definitions. Why is a 16-inch barrel legal, but a 14-inch barrel makes it a dangerous and unusual weapon? This logic is obsolete. If the NRA and FPC succeed in removing SBR and SBS definitions from the restricted list, it will be a massive financial boost. The value of personal short-barreled firearms will stabilize, and you will no longer have to fear becoming a federal felon for simply installing the wrong stock. For FFLs, the demand will explode. Capital flowing into the industry will skyrocket, creating jobs and fueling innovation that has been stifled for years by the ATF's rigid barrel-length rules. The most impactful target of the March 27th filing is the machine gun ban. Since 1986, the civilian machine gun market has been frozen, driving prices to insane levels, tens of thousands of dollars, for items that should cost a fraction of that. This alliance is challenging that ban directly. They argue that if NFA registration is unconstitutional, then banning modern machine guns has no legal basis either. If this holds true, we are looking at the biggest firearm revolution since World War II. You wouldn't have to pay a fortune for an antique. You could access the most modern fire control technology available. Now, we enter the phase of legal warfare. The ATF's counterattack will likely lean on the phrase dangerous and unusual weapons. They will argue that machine guns, or SBRs, are not in common use for lawful self-defense. However, that argument is weakening as millions of AR-15s and modern short-barreled setups are already in the hands of law-abiding Americans. If millions of you own these items without the chaos the ATF predicts, the dangerous and unusual label becomes meaningless. A critical point is the shaking foundation of the Chevron deference. For years, the ATF has issued rules based on their own interpretations of the NFA. This lawsuit demands the court strip that power away. The NRA and FPC insist that only Congress can define what constitutes a machine gun or an SBR. If the court agrees, the ATF's power will be significantly curtailed, restoring transparency to the market. While the ATF will try to delay proceedings to maintain control, the FPC's aggressive push for preliminary injunctions is putting the government on its heels. If an injunction is granted, it will be an absolute floodgate for gun stores. The channel will watch every hearing closely to let you know the moment a legal window opens. Prepare yourselves. The era of the tax stamp might soon be nothing more than a memory of a dark chapter in American history. So, what should we expect in the next 12 to 24 months? We must be realistic. While the March 27th lawsuit is a sledgehammer, the U.S. judicial process is notorious for its delays. The ATF and the Department of Justice will use every resource to stall the day of reckoning. However, the trend is clear. The ATF's power is being pushed into a dark corner of history. My practical advice for you right now is this: stay patient, but stay ready. Do not rush into undocumented modifications just yet, as federal agents are still looking to enforce the dying embers of the NFA. But at the same time, start researching the machine guns and SBR configurations you've always dreamed of. When the NFA finally shatters, the market won't just open, it will explode, and those with the knowledge will be the ones securing the best gear. For those holding high-value NFA collectibles, particularly pre-1986 transferable machine guns, now is the time to consider your investment strategy. If the ban on new machine guns is lifted, the price of aging transferables may dip as modern hardware floods the market. However, historical value never fades. We are moving toward a future where owning a machine gun is no longer a status symbol for the wealthy, but a restored symbol of freedom. The channel will continue to track states with the strongest Second Amendment protections, places where these federal rulings will be applied first and most aggressively. We must not ignore the potential for political blowback. Even if the court declares the NFA unconstitutional, anti-gun politicians will try to circumvent the ruling through local ordinances or new excise taxes. This lawsuit is a clarion call for you to be more active in supporting the organizations that fight for your rights. Our strength is in numbers. The solidarity of millions of gun owners is the greatest barrier against any attempt to re-establish the NFA's shackles under a different name. Looking further ahead, if the NFA collapses, the FFL ecosystem will be completely transformed. Dealers will no longer act as part-time clerks for the ATF. Instead, they will focus on customer service, custom builds, and tactical training. This is a bright future for the American firearm economy. You will experience a fair, competitive market where prices are determined by utility rather than artificial scarcity. Barrel length restrictions and suppressor regulations will become old stories we tell our grandchildren about a time when freedom was priced by paper stamps. As we wrap up today's special report, remember that every legal advancement